Good afternoon, and thank you all for having me. I think the first thing you want to know is about the Alcoder trial. To give you some background, it was a jury trial, as John mentioned, that I did in 2015, and it involved a large claim for personal injuries by a small businessman whose vehicle was rear-ended by an 18-wheeler on the Queensway in Ottawa. It was the second time that the same plaintiff's counsel moved before me to use trial presentation technology on the iPad. In 2012, the first time, in a case called El Backett and Palmer, plaintiff's counsel just used the iPad and a secondary screen to highlight read-ins from medical records and discovery transcripts. Also to illustrate actuarial evidence and to project day-in-the-life video evidence. Little else. Defense counsel did not use it. Jury members did not get iPads. And in El Backett, the jury and I got paper copies of all exhibits, and the court only got a paper record on appeal. In Alcoder, the plaintiff's counsel had iPads for me, for all members of the jury, for defense counsel, and the plaintiff's counsel had planned to tender all Section 35 and Section 52 Evidence Act documents into the record electronically. Defense counsel did not consent to all of the Evidence Act documents going to the jury holus bolus. And in reply, the plaintiff's counsel argued that in most paper trials, the jury receives document briefs with multiple tabs, not all of which are admitted into evidence. And trial judges just instruct the jury to rely only on the records admitted into evidence. Records at the remaining tabs are not torn out of the briefs or taken out. I know that you're going to have an upcoming program on June 24th, but I want those of you who aren't aware to know that the Court of Appeal has just addressed the document management issues that can arise with paper briefs in a case called Giroux and Cunningham. It is a must-read for trial counsel. In Alcoder, the counsel resolved their impasse by having plaintiff's counsel tell defense on a daily basis what documents would be tendered into evidence, subject to arguments about admissibility. Only the admissible documents were then uploaded onto the iPad. So the jury went into the deliberations with a cleansed iPad, uploaded with only the documents tendered into the record electronically. Starting with the Alcoder trial, trial presentation technology allowed for the complete record to be electronic. So what's happened since? Since Alcoder, the same plaintiff's firm has introduced the use of trial presentation technology on the iPad in 5 other cases in the East region. I can't speak to the other regions. I'm sure that Mr. Gluckstein, Mr. Ola, Mr. Gomberg, and Mr. Leah can fill you in on this. Of these 5 other cases in the East region, a third one came before me, but it settled early on in the trial. The other 4 you'll be familiar with because they've all gone to the Court of Appeal for reasons unrelated to the electronic record or trial technology. These were all motor vehicle accident cases, and these 4 were Carolyn McEwen, Rowley and McDonnell, Nemchin and Green, and Patterson and Pelado. In all 5 cases, except Rowley, where the trial judge struck the jury, and that's a question that the Court of Appeal is dealing with, the documents were handled just as they were in Alcoder. The jury received a cleansed iPad for deliberations. The Court of Appeal received an electronic record, And there's really been no change in the use of the technology since. I should point out that in one of the cases, I think it's Carroll and McEwen, if I'm not mistaken, the defense used a separately wired system and tendered documents on a PC. A separate link had to be set up for counsel to navigate back and forth between systems. I'm told this added time and effort to the process and was not without technical difficulties. I cannot speak to the specifics, and I cannot say why counsel chose to use two different systems, whether this was a preference for the PC over the iPad, or whether counsel, for strategic tactical reasons, chose not to reveal, as they did in El-Coder, what documents would be uploaded before examination of the witness. I think you all probably want to know, how effective was the technology? And I can say in one word, very. It was a great way to handle surveillance evidence. In Nemchin and Green, for example, trial presentation technology was used to move through scenes at micro speeds, frame by frame, with precision. As you all know or can recall, resort to the old VCR technology makes it difficult to fast forward or reverse with precision. And from my experience, this affects the overall flow of counsel's examination and cross-examination of a witness. The iPad in El-Coder also helped keep the jury's attention on more, forgive me for saying this, mind-numbing evidence, such as read-ins. It effectively zeroed in on and highlighted key passages. It also effectively illustrated actuarial calculations and made economic loss evidence easy to follow, even fun to witness. Hard to believe, I'm sure, but seeing is believing. I'm sure you all want to know what the jury thought of the technology. And judging only from what I could see and deduce from their behavior, the jury members not only caught on quickly after they got a brief tutorial on the technology, they also helped police themselves and made sure they were all looking at the same document. They were extremely engaged. The worry expressed at the outset that members of the jury would get distracted or would view other documents not in the record never materialized. Also, by the time I did the El-Coder trial, counsel ironed out problems with the location of the secondary screens on my dais and the one used by the witness as oral evidence was heard. Lessons I learned, and I think counsel would probably echo this, is that first of all, the iPad and the PC has not really changed the key ingredients in the trial process. There are witnesses and there are documents. They carry the day. Trial technology is simply a useful tool to effectively locate, navigate, illustrate, and highlight the documentary record. Secondly, in my view, in all cases, the initial hesitancy about using trial presentation technology fell away with counsel's increased comfort using it. You could say this is no different from the growing pains of recent experience with e-hearings on any platform. I'm sure you've all read Justice Meyer's decision in Arconti and Smith, and to quote from him, "It's 2020, and the pandemic has forced us all to find another way to deliver access to justice. Having done so, we're finding fears about the abuse of the technology and amorphous views about the compromise to trial fairness are outweighed by the usability and the effectiveness of the technology." I think the chairs of this program asked me to touch on use of the technology on divisional court appeals. And I have to say that at no time up to my retirement from the bench in May of 2019 did I work on a panel that received an electronic record or heard arguments remotely by video conferencing. The panels I sat on generally worked from large paper briefs with multiple tabs. Counsel would deliver a disc with facta and briefs on it, but this was mainly to help us write the decision. That's all changed since lockdown, of course, starting with the appeal in Nation Rise and Ministry of the Environment. I'm sure you're aware it was hosted on Zoom and a broadcast on YouTube on April 15th. And since then, there have been at least 3 or 4 divisional court appeals, including a very significant 3-day appeal from the decision of the Ontario Human Rights Tribunal in the nurses' pay equity case. The federal court has jumped on the bandwagon. The Supreme Court has also scheduled 4 e-hearings to be heard between June 9th and June 12th. So this is the new normal.
Thank you very much, Justice Roccamo. I just wanted to get your perspective and see if we have any other questions on this while I've got you on any of the issues you might see with the next stage of this. I mean, you've done a trial with the iPads and everything, but we're now looking at a scenario where we could very reasonably see full-on trials with juries remotely, witnesses remotely, counsel remotely, the judge remotely, all convening in a kind of a big Zoom room. Do you think that would work?
I not only think it could work, I think we have to rise to the occasion. I think as the court is revealing in its recommendations for the use of technology, it's something that the court wants to adopt on a go-forward basis. It's inconceivable, the costs involved in most lengthy trials. Certainly the trials that I did were multi-week trials. When you have witnesses coming from hither and yon and counsel coming from hither and yon, the costs are often not proportionate to the claim. So I think it's a real access to justice issue we have to embrace. It's not whether we can do it. It's we need to jump on the bandwagon, wrap our heads around this, and see that it's here to stay. Gone are the days when, for example, I was assigned to a 4-month medical malpractice case with a jury in Belleville that was literally hamstrung by the fact that we didn't have the courtroom, we didn't have the resources, so we scrambled in that case to find alternative courtrooms that could house us all and could house witnesses that were across the country. And it was a nightmare, and that all adds to the bottom line. I think that with the improvements in technology and with counsel's increasing comfort, we can deal with the delivery of access to justice on the technology that we have available. Now, I know there are lots of concerns about whether or not we can be fully comfortable with the trial process and having witnesses comfortable in that setting and also feel the solemnity of the circumstances because they can't feel the solemnity of the courtroom. But my experience is that seeing counsel's face, the judge's face, and the witness's face on Zoom, you can pick up if they have an itchy nose. You can pick up things in their nose. It's that close, and it can zero in. So I don't think we need to worry about whether or not we can determine whether the witness is being shifty. I think the jury can get it too.
Okay, so we're going to move on to Frank in a second, but before we do, I just had this one question from an attendee about the contingency of what happens when the technology fails, or what happened when it failed. Did it fail during El Qatar, and we're down for a morning or down for an hour or something like that?
Not once.
Okay. All right. Well, there you go. Question answered. So